All over again. A quorum being present, the subcommittee will come to order. Good morning, and I welcome our witnesses and members to today's subcommittee hearing to examine the effectiveness of the Occupational Safety and Health Administration, OSHA. This is another one of our efforts to substantially provide oversight to the agencies and programs under our jurisdiction. Today's hearing will focus on how OSHA is ensuring safe workplaces and promoting smart, responsible regulatory policies for both employees and employers. No matter the size of the business, the number of workers it employs, or the industry it supports, workplace safety is the responsibility and should be a chief priority of all businesses. Let me say that again. Workplace safety is the responsibility and should be a chief priority for all businesses. Every worker deserves a safe and healthy workplace. OSHA plays a key role in helping workers and employers make workplaces safe through its health and safety standards, guidelines, educational assistance, and outreach. The agency's policies cover approximately 130 million workers at more than 8 million work sites. Its reach encompasses private sector employers and workers in all 50 states. As a former labor attorney, I know these policies all too well and understand the vast jurisdiction OSHA has over the workforce. While OSHA has standards that provide employees with workplace protections across many industries, employers are continuously struggling to comply with the ever-changing standards and new regulations released by OSHA every year. I have heard from countless employers and business owners who've told me about the challenges they face in complying with OSHA's policies. While these employers agree that OSHA strives to create what it views as the safest working environments for employees, it is often hard for businesses of all sizes to stay in compliance with OSHA standards. Many businesses also agree that OSHA's intentions are well-meaning, but are unworkable in the real world. Furthermore, continuous change comes at a cost to many businesses as they must adjust operations to meet the new standards. These compliance costs are especially difficult for small businesses who have limited resources to meet new, burdensome OSHA standards. The added compliance costs are often passed on to consumers in the form of higher prices. That said, there are programs at OSHA designed to help businesses of all sizes in a proactive way. Just last week, I visited the Centos location in Mobile, Alabama, to celebrate their designation as an OSHA Voluntary Protection Program Star Site. I continue to applaud the local employees for their commitment to workplace safety, and I look forward to hearing more about VPP and other collaborative programs offered by OSHA. Today's hearing will focus on how OSHA can work more cooperatively with job creators, especially in the small business community, to expand its compliance assistance efforts and for employers to provide the safest and healthiest workplaces possible. We also need to see strong and stable leadership within the agency, and I hope the Senate will move quickly on the confirmation of Scott Mungo to be the new Assistant Secretary at the Department of Labor charged with leading OSHA. We are holding this hearing today because it is important for business owners and legislators to hear from one another as new policies are created to foster a safer and healthier workplace for the 21st century economy. It is my hope that the conversations we have today will ultimately benefit workers and employees who are the most valuable resource of every business. I look forward to hearing from our witnesses who've come from various industries, and I thank them for their participation in today's hearing. I now yield to Ranking Member Takano for his opening remarks. Mr. Takano.
Thank you, Mr. Chairman, for holding this hearing on workplace safety, as it has been nearly 2 years since this committee held a hearing on occupational safety, on the Occupational Safety and Health Administration. Over the past 2 years, nearly 10,000 workers were killed on the job, and at least 7 million suffered serious occupational injuries. Over the past 2 years, approximately 100,000 workers have died from occupational diseases such as asbestosis and black lung disease. While the toll of occupational death and injury has declined since the Occupational Safety and Health Act was passed in 1970, there are still 14 work-related fatalities each and every day. Mr. Chairman, the subcommittee received several statements from the family members of workers killed on the job, and I'd like to read one from Tina Tagout of Lawrenceburg, Indiana. My husband, Douglas Tagout, was a roofer and employed by Joel Cornelius Enterprises of Harrison, Ohio, from 2008 to 2013. On September 17, 2013, Doug was fatally injured when he fell approximately 20 feet from a residential roof. The company would not officially inform me of what happened that day. Doug's treating physicians at the University of Cincinnati Hospital advised us that Doug's injuries were too severe. He would never wake up, and we needed to let him go. To be the one who has to give the okay for them to let a person you love most in the world die is something that haunts me day and night. Tina also wrote, everything that I had planned and hoped for our life together ended with me giving the okay for him to die. Her statement notes that Osha investigated the incident and ultimately settled for a penalty of $6,000 for a repeat violation of the duty to fulfill fall protection. She is urging Congress to strengthen penalties as a deterrent. I agree. The minimum OSHA penalty per fatality investigation in 2016 was a mere $6,500. For most employers, this is not nearly enough to cause a meaningful change in behavior. Mr. Chairman, I ask unanimous consent to enter Tina Tagout's statement into the record.
Objection so ordered.
Likewise, current criminal sanctions are inadequate. An employer who willfully violates an OSHA standard that causes a worker's death is currently only subjected to a misdemeanor penalty. A stronger deterrent is needed. The Protecting America's Workers Act, introduced by Representative Joe Courtney, modernizes the Osha Act and strengthens penalties. Additionally, OSHA's ability to protect workers is hamstrung by an inadequate number of inspectors. We can look to the slide ahead of us and behind you and to the sides. Today, OSHA only has the capacity to inspect each workplace within its jurisdiction once every 159 years. We have seen their capacity cut in half over the past 25 years. As this chart illustrates, OSHA had the ability to inspect each workplace every 84 years back in 1992. The problem is simple. It's a lack of inspectors. There are only 1,838 state and federal inspectors on the front lines, covering 8 million workplaces nationwide. Appropriations for OSHA have been effectively frozen by Congress since 2010, when my Republican colleagues took over. The Trump administration budget for 2019 actually cuts OSHA's budget. America's workers cannot afford to have OSHA starved for resources. Congress and the Trump administration are also jeopardizing numerous workers' safety health protections. First, Congress enacted a resolution of disapproval nullifying a rule that requires employers to keep accurate injury records. When workplace injuries are not recorded, patterns of injuries and illnesses are masked from the employer, employees, and OSHA. I have introduced the Accurate Workplace Injury and Illness Records Restoration Act, H.R. 2428, which reinstates OSHA's authority to enforce an employer's continuing obligation to make and maintain accurate records. Second, OSHA has commenced a rulemaking to roll back existing health protections for construction and shipyard workers who are exposed to beryllium, which causes irreversible lung disease. Third, OSHA has signaled it will repeal a rule that increases transparency and better protects workers from retaliation who report workplace injuries. Fourth, OSHA ended work on nearly half of the health and safety protections it had under development. This includes standards to prevent combustible dust explosions, reduce worker exposure to toxic chemicals, and require employers to adopt an injury and illness prevention program. Fifth, OSHA suspended efforts to prevent violence in healthcare facilities, protect workers from exposure to infectious diseases such as Ebola, and prevent major chemical accidents. Deliberate inaction has a high price on workers and their families. For people who have been injured on the job, this is more than just a so-called big government. This is about more than just so-called big government regulations. This is about their family and their future. I hope our witnesses today can outline the costs of inaction and who will pay for that inaction. I want to thank the witnesses for preparing their testimony and appearing here today. I yield back the balance of my time, Mr. Chairman.
Thank you, Mr. Takano. Pursuant to Committee Rule 7C, all subcommittee members will be permitted to submit written statements to be included in the permanent hearing record. And without objection, the hearing record will remain open for 14 days to allow statements, questions for the record, and other extraneous material referenced during the hearing to be submitted in the official hearing record. It is now my pleasure to introduce today's witnesses. Mr. J. Gary Hill is president of J. Gary Hill, LLC in Greensboro, North Carolina, and is testifying on behalf of the National Association of Home Builders. Mr. Hill serves as the Construction, Safety, and Health Committee Chair for NAHB. Mr. Peter Gerstenberger is a Senior Advisor for Safety, Standards, and Compliance with the Tree Care Industry Association in Londonderry, New Hampshire. His responsibilities include developing the Tree Care Industry Association safety and technical programs and managing regulatory affairs initiatives. Dr. David Michaels is a professor in the Department of Environmental and Occupational Health at the George Washington University here in Washington, D.C. He served as the Assistant Secretary for Occupational Safety and Health at the U.S. Department of Labor from 2009 until January of 2017. Mr. Eric Hobbes is a shareholder at Ogletree Deacons in Milwaukee, Wisconsin, and testifying on behalf of the U.S. Chamber of Commerce. Mr. Hobbes' practice focuses on labor and employment with an emphasis in occupational safety and health. I will now ask our witnesses to raise your right hand. Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Let the record reflect the witnesses answered in the affirmative. Before I recognize you to provide your testimony, let me briefly explain our lighting system. You each will have 5 minutes to present your testimony. When you begin, the light in front of you will turn green. When 1 minute is left, the light will turn yellow. When your time is expired, the light will turn red. At that point, I ask you to wrap up your remarks as best as you are able. Now, I'm not really hardcore about that up here, but if you're kind of going a little bit too long, I may interject and say, speed it up, so help me not to have to do that, but forgive me if I do. After you have testified, members will each have 5 minutes to ask questions. I now will recognize each of the witnesses to testify, and we will recognize Mr. Hill for 5 minutes.
Good morning, Chairman Byrne, Ranking Member Takano, and members of the subcommittee. Thank you for the opportunity to testify. My name is Gary Hill. I'm a home builder based in Greensboro, North Carolina, with over 47 years of experience working in residential construction for companies large and small. I also served on the Greensboro Housing Authority, Board of the Builders Mutual Insurance Company, and I'm a charter board member of the Job Site Safety Institute. This year, I have the privilege of serving as chairman of the National Association of Home Builders Construction Safety and Health Committee. As a small business owner, I take very seriously the health and safety of all workers on a job site. I've built close relationships with many of my regular contractors and subcontractors over the years, and their workers are like family to me. I genuinely care about them and want them to be safe from the moment they pick up their hammers in the morning to when they load up their tools at night. Residential construction is one of the most heavily regulated industries in the country. Builders like me try hard to make sure we comply with all OSHA requirements, but the rules aren't always easy to understand or implement. This is especially true for smaller companies that do not have a regulatory expert on staff, or in my case, where the whole business is just me, myself, and I. Often we need help. We want OSHA to be a partner, not an adversary. Let me state this outright. It is OSHA's duty to issue regulations and enforce them, and bad actors that refuse to comply should unequivocally be held accountable. But enforcement should not come at the cost of compliance assistance to the overwhelming majority of good actors seeking understanding and help in meeting their regulatory obligations. Home builders are optimistic that OSHA can fundamentally change its approach to business community in a way that promotes mutual understanding and reduces job site accidents. This process can start immediately by OSHA embracing the following recommendations. Work more closely with trade associations and their members. Identify new opportunities to engage employers to achieve compliance, and improve the communication of compliance assistance information. NAHB has successfully collaborated with OSHA on efforts that have helped builders work more safely as well as save time and money. At one time, NAHB participated in the Alliance program. This relationship broke down barriers between OSHA and the home building industry, promoted information sharing, and helped better the agency's understanding of the unique challenges faced by employers in the residential construction sector. However, in recent years, the agency shifted resources away from many of its cooperative programs in favor of enforcement and punitive measures. OSHA should reinvest in its existing programs, reestablish relationships with industry associations, and foster greater trust from the small business community in its collaborative efforts. In another example, NAHB worked with OSHA to develop a fact sheet and answers to builders' frequently asked questions on the confined spaces rule. This type of simple yet practical assistance was welcomed by small builders and trade contractors seeking better understanding of their obligations. It should absolutely be replicated across all industries for other OSHA regulations. OSHA can also work with trade associations like NAHB to align their member-focused safety programs with what the agency views to be the most critical issues for the industry. This would ensure that OSHA and industry are on the same page when it comes to safety planning. At the same time, OSHA should consider new ways to engage with employers on compliance. This starts with a commitment by OSHA to better and more regularly connect with small businesses, whether through town halls, listening sessions, or online. There are many methods by which OSHA can open new channels of communication with employer community. OSHA should also invest in focused inspections as part of its compliance assistance strategy. Focused inspections place an emphasis on the significant hazards at a constructed job site if an employer has a comprehensive safety and health program in place that includes active employee participation and training. Small employers want help in prioritizing attention to hazards that pose the greater risk of workers being injured. Re-envisioning focused inspections as a compliance assistance measure rather than just enforcement practice will encourage employers to adopt rigorous programs that successfully manage their most common hazards. Lastly, OSHA must improve and modernize its methods of conveying compliance assistance information, starting with making user-friendly improvements to the website and available content. Sufficient guidance is not always available for small business, and when it is hard to track down. In some cases, OSHA produces massive guidance documents that dwarf the length of the rule they were written for. This is not helpful. Guidance should be simple, straightforward, and easy to digest. Improving worker safety is a shared goal. There are many opportunities for Congress and the administration and the home building industry to leverage each other's expertise and resources in the collaborative effort. OSHA can be and should be a partner that starts with the agency adopting a more consultative approach to the regulated community. Thank you.
Thank you, Mr. Hill. Mr. Gerstenberger, you are recognized for 5 minutes. You need to turn your microphone on.
Chairman Byrne, Ranking Member Takano, and members of the subcommittee, on behalf of the 2,400 member companies and the Tree Care Industry Association, we thank you for the opportunity to talk about what a more collaborative and effective OSHA might look like and how that would affect worker safety. I'm the primary contact with our company owners and their employees on safety and compliance matters. I'm also TCIA's liaison with OSHA and similar state entities, working with these agencies to improve safety. Tree care, as I'm sure you can appreciate, is a high-hazard industry. We estimate that 80 or so fatalities suffered annually in our industry gives us a fatality rate that places us among the top 10 and likely among the top 5 most hazardous occupations in the U.S. Our effort to promote safety is multifaceted. We routinely engage our members on safety through education and training. We helped establish and actively participate in the ANSI Z133 committee, which develops the only consensus safety standard for tree care. The Z133 committee was formed in 1968. We have consistently engaged regulators to push for policy change that can improve safety for our members and the multitude of small employers outside our membership. We've been fortunate to collaborate with federal OSHA as well as several state plan OSHAs in the past, with tangible safety benefit to the industry in each instance. We had an OSHA formal alliance for 6 years, and we've engaged the federal agency on multiple occasions concerning rules and guidance. This collaboration has resulted in appropriate regulations for our members who work around power lines, as well as a variety of basic guidance documents detailing the hazards of tree work. The most recent example of this collaboration is federal OSHA's Solutions for Tree Care Hazards info sheet, produced this year. While we appreciate OSHA's efforts to work with us, we're frustrated by the agency's failure to issue a safety standard specific to arborists. This subcommittee requested OSHA consider writing a standard in August of 1998, almost 20 years ago. In 2006, we formally petitioned OSHA. The petition received bipartisan bicameral support, including support of prior chairs and ranking members of this subcommittee, as well as the full committee. OSHA took steps toward issuing a standard during the Bush administration and again during the Obama administration. Changes in personnel and priorities, however, have resulted in delays. The rule is slotted for long-term action on the administration's most recent regulatory agenda. In the meantime, by OSHA's own admission, the agency continues to regulate through a patchwork of standards that fail to address many core safety issues. How can OSHA and TCIA be most effective in what is essentially a shared mission? From our perspective, OSHA could be most effective if it would adopt a rule specific to our industry, and here's why. First, an arborist-specific regulation will guide compliance personnel to proactively look for hazards unique to tree care during their inspections, thus preventing accidents. To illustrate this, we reviewed all OSHA inspections of tree care companies over the past 2 years where Fed rules were cited. In the absence of any accident or complaint, OSHA tended to go for the low-hanging fruit, citing generic safety standards. 50% of the citations were for PPE violations. Another 30% were for failure to wear fall protection in an aerial lift. There was one general duty citation. With post-accident inspections, there's a dramatic shift. 2/3 of the citation addressed the direct cause of the incident. 30% were general duty citations, which means the compliance personnel likely had to research in the tree care industry's safety standard, Z133, to explain the accident causation. The very generic OSHA standards used in 80% of the no-accident inspections were used in less than 1/3 of the post-accident cases. We compared this with the state plans in Maryland and Virginia that have robust rules for arborist safety. In those states, arborist-specific unsafe practices were cited in 37% of the no-accident inspections and in 50% of the post-accident cases. To summarize, inspectors tend to look at workplace conditions in our industry very superficially. When there has been an accident, compliance officers are in many cases forced to research more extensively in order to characterize what the employer should have known or done differently. With an industry-specific rule in place, inspectors will be empowered to readily spot unsafe conditions unique to arborist work. Accident data suggests where the focus of the new regulatory language needs to be, and to add to that and to emphasize, any new standard must address our use of cranes. Cranes, in my opinion, are saving arborists' lives virtually on a daily basis. And the standard that OSHA uses to regulate crane use in our industry is now over 40 years old and not responsive to our industry's needs. Finally, we believe a regulation communicated through outreach and enforcement will promote ubiquity of safe practices in the industry. We estimate there are between 12,000 and 15,000 tree care employers who would be affected by an OSHA rule. The employers most in need of our guidance are, ironically, the ones least likely to have any interaction with us. Our shared challenge is not coming up with the training or guidance needed. That's the easy part. The challenge is getting these employers to pick up this sort of information and take it to heart. In our view, an arbor-specific standard would be a significant instrument for change. Ideally, OSHA will bring forth an unambiguous standard, accessible to all, that comes with the force of law. Thanks again for this opportunity to comment.
Thank you, Mr. Gerstenberger. Dr. Michaels, you're recognized for 5 minutes.
Chairman Fox, Chairman Byrne, Ranking Members Scott and Takano, subcommittee members. Thank you for inviting me. My name is Dr. David Michaels. I'm an epidemiologist and professor of environmental and occupational health at the Milken Institute School of Public Health at George Washington University. The views expressed today are my own and not those of GW. From 2009 to 2017, I served as Assistant Secretary of Labor for Occupational Safety and Health, the longest serving in OSHA's history. The Osha Act established standard setting and enforcement as OSHA's twin foundations. These two tools are supplemented by compliance assistance, outreach, and other activities. There is compelling evidence this formula works. Both strong standards and OSHA inspections are effective in preventing work injuries. Excuse me. In Washington these days, many politicians seldom use the word regulation without prefacing it with phrases like job killing and burdensome. This sentiment is deeply erroneous. First, it's more accurate to call OSHA standards public health protections because that's exactly what they do, protect workers from preventable injuries, illnesses, and death. So when you hear someone talking about rolling back OSHA regulations, they're really talking about endangering workers. The evidence for the life-saving effects of OSHA standards is impressive. Asbestos exposure in U.S. workplaces, once commonplace, is now largely controlled. After the bloodborne pathogen standard, the rate of new hepatitis B cases in healthcare workers dropped dramatically. Grain explosions used to be regular occurrences. Now they're relatively rare. I could go on describing how OSHA standards have saved lives. Second, while there is powerful evidence these standards save lives, there is no empirical evidence. Let me repeat that. There is no evidence that they kill jobs. Here's the truth. OSHA standards don't kill jobs. They stop jobs from killing workers. And while there is much talk of costs to employers of regulations, forgotten in this conversation is the cost to workers and their families of not creating these protections. These costs are enormous and they're tragic. And while the dollar costs are far higher to workers and their families than to their employers, these costs are paid not only in dollars, they're paid in lives. The OSHA standard setting process is exceedingly long, with multiple opportunities for stakeholder input. The Trump administration has proposed cutting the standards budget by 10%, guaranteeing that badly needed standards, like one for the tree care industry, will be further delayed. Enforcement is OSHA's other power tool. In study after study, OSHA inspections have been proven to prevent injuries. And they don't cost employers money, they save employers money by preventing costly injuries. But the agency's ability to inspect is limited by its tiny budget and has been further impacted by the administration's hiring freeze. The administration has proposed a small increase in next year's enforcement budget, but even this increase will not bring staffing levels up to those of 2010. Cuts in the enforcement budget, as the House has proposed, would have devastating effects on workers' lives. Tragically, the Trump administration is already trying to roll back life-saving standards and has failed to fill numerous critical positions, dangerously undermining enforcement. The small size of OSHA's enforcement budget makes it even more imperative to leverage its resources by focusing on high-hazard workplaces, reaching out to vulnerable workers, and using press releases and other outreach to publicize instances of significant noncompliance. This last strategy is inexpensive and it works. It encourages other employers to abate hazards without OSHA having to inspect. In addition, remember that federal OSHA enforces the law in only 29 states. No federal funding increase has been proposed for the state plans. In fact, the budget for these plans is actually lower today than in 2010. Now, compliance assistance also contributes to ensuring that workers come home safe at the end of each workday. But even here, enforcement is key. Enforcement drives employer participation in collaborative programs. Remove the obligation to comply with the law, enforce through inspections, and fewer employers will voluntarily seek help. Many employers, especially small ones, need assistance in learning how to abate hazards, and OSHA provides that. Workers need information about the hazards they face and their rights under the law. That's why the Obama administration provided both employers and workers with strong and active cooperative programs, including the highly effective Susan Harwood Training Grant Program. In summary, it's a false choice to say that OSHA must choose between strong enforcement and robust compliance assistance. OSHA must do both, and during the Obama administration, OSHA did both. But promotion of collaborative programs in place of standards and enforcement is simply not as effective in accomplishing OSHA's vital mission, ensuring that employers protect their workers' lives, their limbs, and their lungs. Thank you for inviting me here today. I look forward to your questions.
Thank you, Dr. Michaels. Mr. Hobbes, you are recognized for 5 minutes.
Thank you, Mr. Chairman. Chairman Byrne, Chairman Fox, Ranking Members Scott and Takano, good morning. My name is Eric Hobbes, and I'm a shareholder in the law firm of Ogletree Deakins in our Milwaukee office. Congressman Grothman, good to see you, sir. I've been practicing OSHA law for about 30 years. My hairline will tell you that. Today I'm appearing on behalf of the U.S. Chamber of Commerce. Ogletree is a longstanding member of the Chamber, and I am a member of its Labor Relations Committee and OSHA Subcommittee. And I am honored to be a part of this hearing. Improving workplace safety is a critical goal that is shared by colleagues from all sides, including, of course, Dr. Michaels and me. The healthy debate among us generally centers on what role OSHA should play, and therefore on what would make OSHA most effective. Throughout my years of practice, I have seen firsthand the role the agency can play, both helpful and unhelpful. In any workplace, the employer is obligated to instill a culture of safety and to provide the necessary training and equipment for employees. The employee is obligated, in the words of the Osha Act, to comply with occupational safety and health standards and all rules, regulations, and orders issued which are applicable to his own actions and conduct. And OSHA's role is to provide employers as well as employees with guidance through regulation and other action, and to enforce the Osha Act fairly, all with the goal of improving workplace safety. Thus, OSHA should be guided by the question, how can we help employers keep employees safe? I'd like to highlight 3 important areas where the new administration can improve in furthering OSHA's mission: attitude and relationships with stakeholders, strategy for improving workplace safety, and substantive policy and procedures. As the title of this hearing implies, a more collaborative OSHA should be the goal. Instead of seeing employers as the opposition, I believe Mr. Hill mentioned this, OSHA needs to regard employers as partners and treat them as such. Employers are the ones held accountable for compliance with regulations and interpretations, and their views, therefore, deserve respect. One area where OSHA needs to listen to employers is in the rulemaking process. Throughout its rulemakings, the agency in the last administration openly dismissed legitimate concerns raised by the employer community about practical issues, statutory authority questions, and assessments of impact. The result was regulations that were driven by ideological views and that will be impractical, if not impossible, to comply with. OSHA also actually sidestepped the rulemaking process to make substantive changes in regulations by interpretations and the use of the general duty clause of the Osha Act, effectively to adopt new rules. Issuing directives on how to write citations for perceived hazards such as workplace violence is the equivalent of regulating without rulemaking. The previous administration's regulating by shaming strategy has proven to have failed, as the most recent BLS statistics show us. That strategy relied on trying to scare employers straight by issuing conclusory press releases at the time of a citation as if the employer already had been judged guilty, rather than focusing on the mere issuance of a citation, which is the beginning of due process, not the end. Instead, OSHA needs to be seen by its stakeholders as a resource for answers, not just a hammer that sees every problem as a nail. Employers, like small businesses with limited safety resources who really need help, should be able to get answers to their workplace safety questions directly from OSHA in real time, as taxpayers can from the IRS, so that they can correct issues in their workplaces and protect their employees. There are several steps OSHA should take that would yield direct results in helping employers improve workplace safety. OSHA has long ascribed to the hierarchy of controls, which you'll see in a slide that's going to appear on the screen in a moment. This is a doctrine to describe how employers must respond to safety hazards. At least that's the way OSHA has used it. While the hierarchy of controls is not wrong per se, myopic adherence to it results in the imposition of unnecessary and sometimes counterproductive compliance burdens and costs. OSHA should reconsider the distinctions between different control measures to allow for more flexible, prompt, and cost-effective responses to various workplace hazards. Another problem has been the inconsistencies between the different OSHA field offices. Each area director frequently has his or her own understanding of what OSHA's standards mean, what OSHA's enforcement authority is, etc. This means that employers with facilities in multiple geographic areas, like many of mine, can and do get conflicting advice from OSHA on the requirements of the same standards and are subjected to different enforcement approaches to identical alleged violations. In addition, during the last administration, more OSHA compliance, safety, and health officers, COSHOs, OSHA inspectors, became increasingly antagonistic and not focused on the promotion of workplace safety. As just one example, rather than using closing conferences at the end of an inspection to tell employers what the COSHOs have found wrong and are going to recommend in the way of citations, the COSHOs either are not holding those conferences at all or are holding them and saying nothing on point. So where is the promotion of workplace safety
Hobbes,
and health?
if you could wrap it up, please, sir.
Yes, sir. In not telling employers what their alleged safety and health hazards are until the citations issue, sometimes months later. In closing, OSHA lost the trust of employers during the last administration. Employers will welcome having a partner in the agency and being able to turn to it as a resource rather than just encountering the agency during enforcement actions. Thank you for this opportunity to discuss making OSHA more effective and collaborative. I'm happy to respond to any questions.
Thank you, Mr. Hobbes, and thank you all, gentlemen. Those were excellent opening statements. We now move to the part of the hearing where members have questions for one or more of the panel members. And we will start with the distinguished chairwoman of the full committee, the gentlewoman from North Carolina, Dr. Fox.
Thank you, Mr. Chairman, and I want to thank our witnesses for being here today and sharing their expertise. As someone who worked in the private sector and owned a small business in the private sector and spends a lot of time at home talking to employers, I agree with the comments that have been made by our witnesses that people in the private sector care a great deal about their employees. They do not want accidents. They do not want injuries. They do not want anything to happen to their employees. They, more than anybody, have a vested interest. They work with their employees. They love their employees. And I think it's a real shame that in the past administration, the attitude was that everybody in the private sector was a villain and that you're out to exploit your employees. I think that is absolutely wrong. Mr. Hill, thank you for coming up from my part of the country to be with us today. As you said, and I hear from small businesses and around the country, that OSHA regulations, however well-meaning, can be confusing and complicated. Small employers work especially hard to comply with OSHA standards. Do you think small employers are aware of the materials that may be available to assist them in these efforts? If not, how can OSHA do a better job of raising awareness about these resources?
Thank you. Thank you, Chairman Fox. I apologize for not recognizing you earlier. It's good to see you.
It's no problem.
That's a great question relative to do our members and small businesses know about the items that are available through OSHA. I think that some do, some don't. I think that those that do or have any idea of where to go versus the website are finding it very, very difficult to search and find information on the website that's pertaining to a specific issue. A good example is this is the OSHA Construction Manual for Regulations, 660 some odd pages. As a small business owner, this is huge. This is a lot to go through to try to find information. It needs to be more succinct. It needs to be more simple. It needs to be more to the point. It needs to be focused on the issues. Things like books that kind of, for lack of better words, dummy the information down is what we need to have. There are fact sheets. There are all these things. Is that information available? It is available, even through our own association, at National Association of Home Builders. Our website will take them to certain parts of the OSHA website to find some of this information. And we, on a regular basis, we are sending out this information so that our members are aware they can get this information. We recently, just this year, started a program called Safety 365, where we are sending to our members and recognizing a specific issue or a specific area that needs to be focused on every month to all of our members. So the information is there. Some know it and some don't. We're doing our best to try to get that information out to all of our members and to anybody else that we can.
Thank you very much. Mr. Gerstenberger, we spend a lot of time, as Mr. Hill has mentioned, discussing the need for common sense, workable regulations when it comes to OSHA standards. Can you further expand upon why the tree care standard you're recommending fits that description? And let me tell you, I use arborists. We use arborists at our place a lot, and I am very grateful to them for what they do.
And as you use those arborists, you can appreciate the nature of our work and the hazards we can find in it. Well, quite simply, we feel we need a rule as opposed to any kind of compliance assistance or outreach efforts, because rule simply has more gravity. We feel we need the prescriptive requirements that could be found in such a rule to guide us, to provide guidance particularly for the smallest of businesses who, as Mr. Hill illuminated, sometimes struggle with the sheer weight of or vagueness of the OSHA rules that exist right now. Very prescriptive rules with clear-cut guidance telling us how to operate brush chippers, how to climb trees to some extent, how to do the things that we do and do them safely, we feel would go further, a long way to improving worker safety in our industry.
Thank you very much. Thank you, Mr. Chairman. My time's expired.
Thank you, Dr. Fox. The chair now recognizes a distinguished ranking member of the full committee, the gentleman from Virginia, Mr. Scott, for 5 minutes.
Thank you, Mr. Chairman. Dr. Michaels, what are the harms from beryllium exposure?
You turned it off.
Beryllium is an amazing metal. You know, it's stronger than steel but lighter than aluminum, but it causes what we call chronic beryllium disease, which is a terrible, debilitating, and sometimes fatal lung disease, and it's also a carcinogen. It causes lung cancer.
And what are the, how out of date is the OSHA beryllium standard?
Well, before early 2017, when we issued an updated standard, the standard dated from the Atomic Energy Commission in 1948, essentially a standard written for the nuclear weapons industry to stop acute beryllium disease, people dying after a short time when they were exposed. So the Department of Energy, where I was Assistant Secretary in the late 1990s and where much of the beryllium in the country is used, issued a standard 10 times stronger than OSHA's old standard in 1999 or 2000. And so OSHA's way behind, was way behind.
Why is it called the taxi cab standard?
Well, because the standard was essentially two AEC scientists were in a taxi cab and they said, let's figure out a number that will prevent these terrible deaths from occurring. And that was effective in 1948 for these acute cases, but not for preventing chronic beryllium disease.
Now, why did OSHA decide to cover construction and shipyard workers?
Well, in our, the OSHA standard actually came from a negotiated relationship between the Steelworkers Union and the primary beryllium producer that came to us and said, we need a new standard, just as the tree care industry has said we need a new standard. They came to us with a proposal. We issued the proposal, and one of the alternatives at the recommendation of NIOSH and many others was we asked the question, should we cover maritime and construction workplaces as well, because there is beryllium exposure associated with abrasive blasting. We asked the question in the proposed rule. We had a public hearing. We received plenty of comments back with data saying this is the exposures in these industries. Different opinions. The maritime industry wrote in saying they thought we should strengthen the PEL, the permissible exposure limit, but not some other things. So we added that to the final standard, and we issued that standard in January 2017.
Who opposed the new standard?
Well, after the standard came out, we heard that the blasting materials manufacturers, and primarily a company called Hospitalized, which make coal slag that's used as abrasive blasting, and the coal slag is contaminated with beryllium, and they would be affected. And frankly, this is a market question. There are other materials that can be used for abrasives. The coal slag abrasive people said, you know, if you make people use a safer product, they're not going to buy our product, so they've opposed it.
What are the safer materials?
Well, glass, recycled glass can be used as an abrasive material. Many employers have already shifted. In fact, one of the largest users of abrasive materials in the country, the Newport News Shipyard in your district, Mr. Scott, has already stopped using coal slag and has moved to glass as an abrasive.
Thank you. Can you tell me what the Volks rule is?
The Volks rule, well, the Volks is a decision that was, the court gave a decision that OSHA's record-keeping rule was poorly written, and essentially the Volks decision said that OSHA couldn't cite an employer for a record-keeping violation unless it was with 6 months of that violation actually occurring. In other words, when a worker being injured and the injury not being recorded on the log at all or accurately. The problem with that decision was OSHA rarely is there right when a worker is injured, and it takes some time to issue the citation. So essentially, the Volks decision made OSHA's record-keeping rule virtually unenforceable. And so the Volks rule essentially returned to the position that OSHA had for 40 years, essentially, which is that OSHA has essentially 5 years following an injury not being recorded correctly to cite the employer for not recording it.
Under present staffing limits, how often do businesses get visits by OSHA?
Well, OSHA does one visit, as you saw from the numbers. OSHA can visit every workplace in the United States once every 159 years, and most places OSHA doesn't ever get to, and when they do, it's often long after an injury has occurred.
So what are the chances of being caught within the 6-month period?
Well, this is the problem. Because of the Volks decision and the Volks, OSHA tried to change this Volks rule, but it was overturned by Congress in the Congressional Review Act. Essentially what this does is this makes OSHA's record-keeping unenforceable. Employers, low-road employers who don't want to record injuries will never be caught, and that's going to make the better employers, like some of the people on this panel, look like they have high-hazard facilities. Their workers are being injured, and they will be under pressure to lie as well. It's really a disaster.
And since OSHA doesn't have enough staff to visit everybody, don't they use these records to decide who needs to be visited?
Exactly. I mean, OSHA gets these records now electronically, and OSHA will use that for targeting.
Dr. Michaels, if you could wind it up real quickly.
Thank you. And when OSHA goes into a workplace, they look at these records to find where the hazards are, and by not being able to enforce accurate records, I think many workers will be hurt.
Thank you, Mr. Scott. I now recognize myself for 5 minutes. Mr. Hobbes, it's been 124 days since Scott Mugno was nominated to be the Assistant Secretary for Occupational Safety and Health, and we are all anxiously awaiting his confirmation. In your view, what difference will it make for OSHA's priorities and policies to have Mr. Mugno confirmed?
Thank you, Mr. Chairman. The answer is that nothing that we're talking about here as a reality will come to fruition, will be put in place as policy until we have an Assistant Secretary. Reasonably, those who are in charge of the agency in the absence of an Assistant Secretary are placeholders. Nothing will change is the answer, and that's a problem.
Also, in your testimony, you discussed the need for OSHA to consider regulations which meet legitimate demonstrated needs to address safety hazards and which are data-driven. Can you further explain how OSHA should approach rulemakings?
Yes. The identification of a need should be the trigger based upon which the agency promulgates a regulation. I mean, and I would suggest that several of the regulations, not including Beryllium, by the way, but others and rules, have not been triggered by a perceived need. The electronic record keeping or reporting rule is one, I believe. I don't believe there was any perceived need at all. But the important element of the creation of a rule, even statutorily, is that it be supported by appropriate data. Data that says this is the problem, and data that says here's the cost of addressing the problem as a way of A, B, or C, or in the way of A, B, and C. To be clear, we on the management side are not opposed to enforcement. In fact, Dr. Michaels has spoken of the 2 pillars. It's really a 3-legged stool, not a 2-pillar system. We have regulation, enforcement, and assistance, compliance assistance, but it must be all 3. And all 3 cost. So the question is, what will the cost be of a particular regulation to address a particular need, depending upon how it's addressed?
Mr. Hill, your background experience demonstrates that you clearly have a great understanding of the construction industry. In your testimony, you discussed how the development and use of fact sheets and questions and answers are helpful in assisting small contractors in complying with OSHA standards. Can you expand upon why this is so important, especially when it comes to OSHA regulations?
Be happy to. Thank you, Mr. Chairman. As I mentioned before, we're looking at 660-some odd pages in the regulations. It's these focused fact sheets, Q&As that are available that help our small business owners guide through this book. Without that, this would be really, really difficult. So using that kind of information that we can hand out to our small business owners, particularly because they're in the field all the time, this is going to be difficult for them to carry out. If they've got something in their hand that's a fact sheet, they can use that very much. The other thing is the website, and I've mentioned that before. The website needs to be brought up to today's standards. And what I mean by that is you can actually go on the website on your cell phone or your smartphone, but when you search for something and you pull in a document, you're seeing a PDF with very little tiny letters, and it's very difficult to read. So a lot of our small business owners are using their smartphones in the field. Let's get something where we can have an app where we have access to a smartphone-friendly environment through OSHA and their website. Very much needed. Thank you.
Also in your testimony, you say that OSHA should pursue collaborative relationships with trade associations and acknowledge the expertise these groups possess. I often hear that there's a loss of trust between employers and OSHA. How do you think trade associations could help OSHA restore that trust and improve workplace safety? Are there other ways the two can work together?
Mr. Chairman, there are several ways that we can work together. In my own personal experience in North Carolina, of 47 years in this industry, I have learned that when there is a need for a regulation or there is a need for an ordinance, it has become, to me, that it is much better if you can pull the partners in that have stakeholders in that specific issue. And what I mean by that is early on, when there's a thought of a regulation or there's a thought of some sort of mitigation that needs to be done, bring those groups together, let them be a part of that work. Let them be a part of formulating the information or implementing and coming up with the ideas that might make safety much better. I have found that when you do that, then we partner with OSHA, we come and we're all saying we're agreeable to this, so it gets met with less resistance if there's stakeholders involved in that.
Thank you, Mr. Hill. My time is up. I now recognize Mr. Takano for 5 minutes.
Thank you, Mr. Chairman. Mr. Michaels, Professor Michaels, there are 3.5 million workers with serious injuries each year, and most experts believe the real number is triple that rate. Meanwhile, 25% of all prescriptions written under workers' compensation programs were for opioid medications. That number is up around 30 to 60% for construction workers in one study. What policies should state workers' compensation programs put in place to reduce workplace injuries?
Well, Mr. Takano, you're raising an important and interesting question. And obviously, the opioid epidemic is on everybody's mind and something we have to address. Clearly, a component of this epidemic are workers who are injured and then go on to painkillers, some of whom then go on to addiction. And there's some important work being done by the workers' comp system in Washington state to try to change the way prescriptions are being done. But another big component of this growth of the epidemic is workers who are injured who don't go on to workers' comp. They need to work, and so they self-medicate. And we've seen this all across Kentucky and West Virginia among coal miners. The way to address this, of course, is to prevent those injuries from occurring. Some state workers' compensation systems now offer incentives, lower rates, if an employer has a comprehensive safety and health management system. And I think starting to do this and saying, if people aren't injured, we can control their painkillers. If they are injured, we have to work closely with them to get them back to work without their painkillers. The workers' comp system can play a very useful role in addressing this epidemic.
So really, there's an economic self-interest on the part of employers vis-a-vis their workers' comp insurers to be able to, in conjunction with this opioid connection here.
Absolutely. I think this is a win-win for employers, for the workers' comp insurance industry, and, of course, for workers and their families.
And let's not lose sight of what we're getting at here. We need to reduce workplace injuries so that employees, whether they're covered by a workers' comp policy or not, so they don't self-medicate and we don't overprescribe if they are covered. Your testimony noted that nothing focuses the mind for employers who deliberately flout the law and endanger workers like the prospect of time in jail. Yet you point to weaknesses in the criminal provisions which make them a weak deterrent. What should be done to reform the criminal sanctions in the Osha Act?
The Osha Act's criminal provisions are virtually meaningless. If a worker is killed and it's a willful violation, the maximum penalty is a misdemeanor. Maximum time in jail is 6 months, but usually it's against the corporation. It doesn't see any jail time. So U.S. attorneys never take these cases. They simply won't bother. It's a waste of their time. The Protecting America's Workers Act, which has been introduced several times, has criminal provisions that look very much like those in Canada and other countries.
And let's be clear, we're talking about willful violation.
Willful violation. If a worker is killed and it's not a willful violation, even though we think that it looks like there should be some criminal penalty associated with it, there is no federal law that's, where that employer can be prosecuted. It's simply a misdemeanor. And if there's not a willful violation, it's not even a misdemeanor.
Yet terrible things can happen, and there's always an urge in a terrible moment like that to fix the blame on somebody. But if it was truly an accident, it shouldn't be a felony. But if we're talking, what is the standard for a willful violation?
Well, a willful violation is essentially beyond even knowing. I mean, the employer knew or should have known the hazards and essentially took deliberate indifference and didn't
calculated because they're motivated by profits, whatever.
Well, we don't look at motivation. We look at what we don't say was that they were trying to save money, but if they knew and essentially put this worker willfully in this situation where they were hurt, that's a willful. So the criminal penalties regarding OSHA relate to OSHA violations and workers being killed are virtually never applied. I mean, the number of cases is tiny over the last 30 years.
Well, it boggles my mind that sounds like a pretty high standard for a willful, to define as a willful violation, and yet for such a violation, we only have a misdemeanor penalty, which is a slap on the hand. Prosecutors don't even want to waste, their valuable time and resources on such cases.
Correct. There have been recommendations and laws introduced that would strengthen that, essentially mean if a worker is hurt, they don't have to be killed, but an employer knowingly puts the worker in that situation, you should have a criminal penalty. In Europe, there are some very strong penalties against directors and managers of workplaces, and they have had a huge impact. When a member of the board of directors or the manager of an operation knows that they would face criminal penalties if they made that worker go up there on the top of the roof with no fall protection, and we've seen that over and over again. When there's fall protection on the site and the employer says, you don't really need that fall protection, go up there right now, just do it without fall protection, and the worker's killed, we need something stronger to make sure that doesn't happen.
Well, thank you. I'm sorry we went over our time, Mr. Chairman. I yield back.
Thank you, Mr. Takano. The chair now recognizes the gentlewoman from Georgia, Ms. Handel.
Thank you very much, Mr. Chairman. I am very encouraged that we are having this particular hearing. I hear from small businesses in Georgia's 6th District every single day about the extraordinarily onerous impact of regulations, not just out of OSHA, but from other regulatory agencies as well. And to be sure, we've moved into, over the past 8 years, a very punitive approach in how the regulatory climate was enforced. Mr. Hobbes, I'd like to start with you, and thank you to each and every one of you for your insights today. One other issue that I do hear repeatedly is the need to ensure consistency in the enforcement of the OSHA standards. You mentioned a little bit about some of that across the various OSHA field offices. So what can we do to address this problem so that we're going to have employers can receive consistent and accurate interpretation of the regulations, that they will also be able to drive consistent compliance and ensure fair, equitable enforcement?
Thank you, Congresswoman. That consistency issue is a big issue in the field. It's of great concern. On the employer side of things, as I said earlier, we are not opposed to enforcement or, for that matter, regulation. What we need is smart enforcement and smart regulation. And we've seen an increase in what I will call less smart enforcement, especially with the graying of OSHA and the replacement of seasoned compliance officers with new compliance officers. So I think a fundamental part of the problem is training. I think a fundamental part of the problem, it goes to something that Mr. Hill raised, which is that the standards themselves and even the compliance guidance is so complicated, that people who are in the field as safety and health compliance officers don't understand the standards themselves. In fact, I've run into area directors who do not understand the standards themselves. One of OSHA's landmark standards is called the Lockout, Tagout standard. It requires the isolation of energy when employees are working on a machine. One of the requirements of that standard is that there be an annual inspection of the program the employer has. And the standard lays out essentially what that inspection must involve, and the compliance guidance that OSHA's given us goes further. And various area directors have very different views of what that inspection must include, and most often they're all wrong. By that I mean what they believe is the case is not consistent with what even OSHA's compliance guidance provides. So the imposition of consistency must be from the top, and to be frank with you, the hires must be, I think, greater in number but greater in quality. Again, it's quality of enforcement that's important to employers.
Excellent comment. So a greater focus on plain language explanation of these regulations.
That would help tremendously. And plain language for employers to understand what they must do, not just what the standard says, and then plain language for the compliance officers to understand what employers must do.
Okay, great. One more question for you, Mr. Hobbes. You mentioned in your testimony that one of the best opportunities for employers to be able to provide input to the agency during the regulatory process is in conjunction with the Small Business Regulatory Enforcement Fairness Act panel. When OSHA moves forward with rulemakings in the future, what information should it be sharing with the panel of small business entities to help ensure that the agency does have responsible, common sense, workable, implementable policies?
The SUBREFA process, which is the acronym and the shorthand, already provides the mechanism. In fact, it mandates that an agency like OSHA provide to the members of the panel that's been called, the small business panel that's been called, the proposed regulation and the impact assessment or assessments that have been done by the agency to determine what the impact of that new regulation would be on small business. This is more a timing issue than it is a what needs to be provided issue. The timing of those panels must be early enough on in the process that the small business panel itself can respond, and those changes proposed or comments made can be taken into account by the agency to change what that regulation might otherwise have been.
Okay, great. I just have a couple of seconds left. For you, Mr. Hill, small business has clearly been impacted by overregulation as well as a punitive attitude. With the additional budget resources proposed, over $5 million in additional monies going into compliance assistance, is that going to help? And that might be a yes or no.
I think at this point anything's going to help.
Right.
Will that solve the problem? Probably
Thank
not.
you. Mr. Chairman, I yield back.
Thank you, Ms. Handel. The chair now recognizes the gentleman from Arizona, Mr. Gahalva, for 5 minutes.
Thank you very much, Mr. Chairman. Dr. Michaels, I found curious one comment that because we don't have a permanent confirmed head of OSHA that nothing's being done within the agency, and it sure seems with all the rollbacks and ending of rules, freezing of potential rules down the road, that a lot of work seems to be going on all these rollbacks. The Trump administration has terminated all work on health and safety protections needed to prevent combustible dust fires and explosions. to require injury and illness prevention programs, to cover infectious diseases, and to update obsolete exposure to toxic chemicals. Dr. Michaels, what's the cost to worker health and safety from this deliberate decision to end or stop work in all these areas? And what percentage, second one, of toxic substances have OSHA has exposure limits to? Those two.
You know, you've raised a very important question. When we talk about cost of regulations, you know, OSHA tries to figure out what's the cost to employers of implementing certain things. But in fact, the cost of not issuing regulations, the cost of delaying them, is significant. It's estimated that the Beryllium standard will save 92 lives every year. If you delay that for 2 months, which I hear rumor is what OSHA is planning to do, that's essentially sentencing to death 8 workers every month. We don't know who they are. That's the problem with public health. You don't identify who got sick because you did this. But by delaying standards, it means hundreds of people won't be saved, diseases won't be prevented by those standards. And that's the problem. So things are going on, and they're unfortunate. You know, OSHA standards take 15, 20 years to develop. That's how long silica, beryllium took. By essentially stopping the process now, once administration comes in that decides to move some of these standards forward, and we hope that the next Assistant Secretary will agree that those are important, because as you heard from Mr. Gerstenberger, employers want standards. Once they start moving forward, years will have been lost.
And whistleblowers, your recommendations to strengthen that, since your testimony, you say it's plagued by enormous problems, and essentially the provisions protecting workers under the Act are weak. Any reforms that you would recommend, given the backlog and everything else that's going on with that program?
Well, you know, the OSHA, it's not very well known, but OSHA not only has its own whistleblower protection program, but OSHA is the enforcement agency for 21 other statutes, including Clean Air, Clean Water, Dodd-Frank. When I arrived at OSHA, there was virtually no funding for that office. It was a backwater. We were able to get its own budget line, its own SES person to run it. We made it a very high priority. We put together a very valuable whistleblower protection advisory committee with employers, worker representatives. The Trump administration has announced they want to end that advisory committee, which I think is foolish. But also, right now, the ability for OSHA to protect whistleblowers is very limited. And there are a number of provisions in the Protecting America's Workers Act which will strengthen that, and essentially make sure that workers can raise their voice and talk to their employers without fear of being fired. Because OSHA, as we've discussed, can't be in every workplace all the time. They can only rarely be in workplaces. So workers have to be able to point out hazards without fear of being retaliated against.
Thank you. Mr. Hobbes, one question. On April 11, 2011, the letter from the U.S. Chamber of Commerce to the Department of Labor states that OSHA's permissible exposure limits for toxic substances are obsolete. It states, exposure limits were adopted when OSHA was created in 1971, based existing consensus standards. Consequently, there is a wide consensus that many of these limits do not reflect current technology or contemporary understandings of exposure levels, and that should be updated. I note that the Trump administration's regulatory agenda terminated all work on updating OSHA's permissible exposure limits. In your view, sir, is that current permissible exposure limits are sufficient to protect workers, given the letter in 2011, and I understand no action since then?
I'm unfamiliar with that letter from 2011. Thank you. Dr. Michaels has it in his materials. I do not disagree, nor do I believe that the Chamber disagrees that the PELs, the permissible exposure limits, in many cases are outdated. I think there is agreement on that. The question is, how do we go about updating them? By what process? In what order? And I do not know what the termination of the process of looking at that by this administration, this present administration is.
Dr. Michaels, you on this?
I do. You know, we worked very hard having major stakeholder meetings with the chemical industry, with many employers to say, okay, how do we update our PELs in a way that's more efficient? Because so many employers come and tell us they need stronger standards. To take this off the regulatory agenda and to announce that for every new standard we have to withdraw two, essentially will assure that employers will not get the stronger standards they
Dr.
want.
Michaels, if
and
you could
workers
wind
won't be
up,
protect-
please.
And workers won't be protected.
Thank you, Mr. Chairman.
Thank you, Mr. Grijalva. The chair now recognizes the distinguished gentleman from South Carolina, Mr. Wilson, for 5 minutes.
And thank you, Chairman Byrne, for your leadership for workforce protections. Mr. Hill, I appreciate your testimony on behalf of the National Association of Home Builders. You make a difference with your insight as the chairman of the Construction Safety and Health Committee, as well as your 47 years of experience in the residential home construction industry in both Carolinas. As a real estate attorney myself, I'm a grateful multi-year member of the Home Builders Association, appreciating your creation of jobs and opportunities. In your testimony, you mentioned that the 95% of the National Association of Home Builder members meet the federal definition of small entity as defined by the U.S. Small Business Administration, and that federal regulations cost small businesses 60% more per employee than large businesses. Can you elaborate on the challenges these small firms face in trying to comply with OSHA regulations and reporting requirements? Also, how do the costs associated with compliance affect both industry and consumers?
Thank you for your question. It kind of goes back to some of my earlier comments about not having staff in order to accommodate some of these requirements and some of the issues, and being able to do that. So it makes it very difficult. As in myself, as I mentioned, I do everything myself, everything I have to do. So it becomes very cumbersome to go through the regulations, understand the regulations, and because of that, I've got to either go out and get additional information from outside sources, consultants, engineers, attorneys, in order to help when I need that help. So that in turn is going to raise the cost of me doing business as a small business owner.
And this affects the cost of a home and the ability of people to buy homes.
Yes, sir.
And again, home builders are among the leaders, civic leaders of our nation. We appreciate very much your service. And Mr. Gerstenberger, it is clear in your testimony that the Tree Care Industry Association is focused and passionate about worker safety. You've been pushing greater standards for years. I appreciate trees so much that I introduced legislation when I was in the state Senate barring the cutting of trees on the right-of-way of highways which had a circumference of 7 inches or greater without a public hearing. I like trees. So and the Highway Department, Mr. Chairman, was not pleased, all right? They certainly let me know right away. As you explained in your testimony, without a specific OSHA standard for tree care operations, the agency applies a patchwork of standards that lacks clarity and fails to address core safety issues facing workers. In addition to implementing a federal industry standard, are there other things you would do with OSHA that would further worker safety in the tree care industry?
Thank you for your question. And may I just add that, Congressman Wilson, we appreciate the fact that you've signed on to letters to OSHA supporting our industry's efforts to get a separate standard in the past, and we really appreciate your support. In terms of other things that we could be doing with OSHA, first and foremost, I'd have to say that we feel the process has to start with a separate standard. But beyond that, any outreach activity or enforcement, we would, based upon a separate standard with OSHA, we feel would be in and of itself more effective with the black and white rule to fall back on. We have engaged with OSHA, as I mentioned in my testimony. We had a formal alliance with OSHA for 6 years, and through that alliance we produced a lot of safety outreach materials. We could continue to produce those sorts of materials. Nobody has discussed the Susan Harwood Grant Program today. We don't know its future, but I will say that we have been the thankful recipient of many Harwood grants in the past, used that money to produce a lot of effective training and convert a lot of folks in our industry and open eyes and change attitudes. We'd love the opportunity, if that were to continue to do training, meaningful training for people in our industry. But again, I think everything is based upon and has to start with some black and white rules that are prescriptive for our industry that are easy to follow.
And additionally, Mr. Hobbes, we appreciate the U.S. Chamber's efforts to support the tax cuts creating jobs. Additionally, can you explain OSHA's Voluntary Protection Program and Alliance Program their effectiveness to improve workplace safety?
The VPP thank you, Mr. Congressman, I appreciate it. The VPP program through the years has proven to be an excellent program. The difficulty is that it applies only to a small slice of industry, and it must be paired with other compliance assistance for all employers to be able to get to the level or somewhere near the level of safety enforcement and program quality that the VPP members do. And the prior administration, there was lip service to VPP, in my view, but there also was a lessening of funding for VPP in favor of enforcement. And even as I recall, a proposal, I don't know whether it ever made it to a proposed rule, but a proposal that members of VPP be subjected to inspection. Part of the VPP program is, if you will, an out from inspection because the reporting requirements are so onerous and so significant as to what's going on week to week.
Thank each of you for being here.
Thank you, Congressman.
Thank you, Mr. Wilson. The chair now recognizes the distinguished gentleman from New Jersey, Mr. Norcross, for 5 minutes.
Thank you, Mr. Chairman, and certainly appreciate the fact that we're talking about job site safety. In my career, I've been on a job 3 times when a person's been killed. When a guy standing next to me rolled off a scaffold and died. To have his daughter come find her dad's car, who would never drive it home. Safety doesn't know the difference whether you're a one-man shop or a 100-man shop, because we hear time after time that small business is overregulated. But when it comes to safety, it's not. It's not okay for a small business to let their employees die, but big business, it's okay. There is no difference. Let me say it again. There's no difference on the size of your company when it comes to employee safety. The manual that I saw, Mr. Hill, that you were referencing, hey, you ever see the electric code? You ever see the legal codes? The size of the book is irrelevant. Having straightforward rules and regulations, we understand. But do you think it's OSHA's job to tell you how to run your company or how to be safe? Or is it your job to know how to be safe and then they overview and oversight with you? Mr. Hill, whose job is it to be safe?
Mr. Representative, it's everybody's job to be safe.
But is it OSHA's job to tell you how to be safe?
I think we need interpretation. I think we need to have,
I understand, but is it OSHA's responsibility or is it the owner's responsibility on knowing how to operate safely?
Well, I go back to my earlier answer. It's everybody's responsibility.
So you're saying there's no liability for the owner? It's everybody? The liability goes back to the owner, correct?
In terms of liability, that is
okay.
correct.
Well, which drives so much of what we do each and every day. And I want to talk about the tree trimming business. Very specific rules. There are some things unique in that. But when it comes to fall protection, which you cited is the #1 issue, that's the #1 cause of death in the tree trimming industry, are falls. Not wearing fall protection is not complicated, is it?
No, it is not, Mr. Chairman.
It's very strong. No, I'm not chairman.
Yes,
Chairman's over to my left. The #2 cause, being struck by trees, that's about rigging. How many hours of training does your first line, step 1 worker have before he or she goes out to the job site?
That's an interesting question, and the answer is that the amount of training given is really literally all over the map. We worked with the state plan in Maryland to implement a work rule there, and I'm thankful to see that that work rule implemented in the state of Maryland carries considerable provisions for what type,
I'm not asking
how much.
what we're regulating. In your industry, what is the minimum standard for safety training before that new employee walks out into the job?
There is no established standard.
So your tree trimming business has no standard for safety training before they go out, which you admit is one of the most dangerous
We have in our consensus safety standard, which we certainly hope that...
So how many hours is that?
It's not equated to a number of hours. It talks to actionable items that need to be included in training and that training has to establish competency.
So you, as the safety expert in the tree trimming industry, have never set a standard for when somebody goes out to work for you. Not rigging, not fall protection, not line clearance, the three major causes of death in your industry, and you have no standard?
We have standards that establish what a competent person needs to be and what they need to be trained in. We do not prescriptively say it must take X number of hours.
But you want OSHA to tell you.
No, we don't necessarily want OSHA to tell us how many hours we train either.
And this is the point I'm trying to make, and thank you for your testimony. It doesn't matter if you're big or small, but taking responsibility primarily falls to the employer. You don't get to shove that off and say, gee, it was his or her fault. These are people's lives that we're talking about. And overregulation doesn't come into play, because how much does it cost when a person dies?
I'm sorry if my testimony implied that we want to shove our responsibility off to OSHA to solve our issues. First and foremost, our members want to see their employees come home at the end of the day in better condition than when they showed up in the morning. And we realize, first and foremost, that's our responsibility. What I'm trying to say here is that we want OSHA to partner with us in that process, and we feel they can be more effective at doing that by adopting a specific work rule for our industry that will particularly help the smallest of employers understand and comply.
Line clearance, fall protection is not unique to your industry. Those are things that you can do, which is number one and number two cause of death. I yield back the remainder of my time.
Thank you, Mr. Norcross. The chair now calls on the gentleman from Wisconsin, Mr. Grossman, for 5 minutes.
One more time, we'll just point out to members of the committee, we have 4 wonderful witnesses here, 3 picked by the majority and 1 by the minority, and there's 1 professor, and that's picked by the minority. So, I don't know, it's just a pattern we see again and again. I have a question for Mr. Hobbes. We had an incident in my district where somebody found out that they were going to be subject to fines through the media. In other words, apparently the local media was notified that a fine was going to be levied before the business, which I can only assume was grandstanding or something on the part of OSHA, and of course the business didn't even feel they should be fined, so it seems a little inappropriate. But is that something you've ever had happen, or what is the process they're supposed to be going through?
Thank you, Congressman. Yes, we have had that happen. I should say clients have had that happen to them. When OSHA, at least under the prior administration, when OSHA issued a citation, it made those citations or that citation available to the media, and the media watched closely. And in part, I think this is the media's fault and not all OSHA's fault. But the press releases which accompanied those citations, which I addressed in my submission and in my comments today, stated as fact what simply was alleged in the citations, so that an uninformed public reading an article on the citation would immediately infer that the employer was guilty. And this is like any complaint or charge filed in a civil or a criminal matter. It's an allegation only until it's proven.
How do you get your reputation back if OSHA alleges something which may not be true, decides to put it in the press, and then perhaps later is shown not to be right?
You put your finger on it, Congressman. The press releases that OSHA issued during the prior administration were never even modified, never mind withdrawn, if at the end of the process, as a result of settlement or as the result of litigation, the allegations were shown not to have been truthful in fact.
Do you think there should be some legislation requiring a waiting period after a business is notified that they're being fined before OSHA can grandstand or try to get their name in the local newspaper?
To be fair, I haven't thought it through that far, Congressman.
Okay. Another instant here. Employers have 24 hours to notify OSHA that an employee has been hospitalized. Now, there may be cases in which you don't even know an employee's been hospitalized. You can have a situation where somebody was at work on Friday, goes home, decides to go to the hospital. Employer doesn't hear about it for 72 hours or whatever. Would you, I guess I asked Mr. Hobbes because he's from Wisconsin, so I automatically assume he's got the right answer, but anyone can respond. Is this a problem, or do you have any suggestions how to deal with it?
It is a problem. The timing is a problem, but the bigger problem is that it's very difficult for employers to get information from healthcare providers about what, in fact, is going on with an employee once that employee is gone from the workplace. Healthcare providers are very, very sensitive to the confidentiality of that information, so we may not know for a very long time whether an individual has been inpatient overnight and for treatment, which are the two keys to that reporting requirement, and it is problematic.
Okay, Dr. Michael.
If I can add, the reporting requirement says, though, that the employer has 24 hours to report 24 hours from knowledge of the hospitalization, and that actually is triggered by the overnight stay. So if a worker goes home and then is hospitalized on a Saturday night and the employer either doesn't hear about it or hears about it on Monday, that's fine. The purpose, though, is for OSHA then to engage the employer to say what happened at that workplace. In the majority of these cases, and that's what's often forgotten, OSHA doesn't inspect. They partner with the employer to do what's called a rapid response investigation. They send materials to the employer and say, can you figure out what happened here? Why was the worker hurt? And tell us what you learned and what you're going to do about it. And that's the end of it. And so this idea that OSHA isn't partnering around this is, and OSHA looks at employers as villains, as was suggested earlier, is really discrediting an agency, and it's not based in fact.
Oh, careful. Those reports frequently result in inspection, Dr. Michaels. It's not only the RRI process.
But the majority do not.
Well, that's because OSHA doesn't have the resources, not because it would prefer not to show up and inspect.
No, I made the decision that it would be more useful to inspect places which workers have not been injured, but to engage those employers, because that's a teachable moment. An employer cares about their employees. Everybody acknowledges that. If a worker has been hurt, that's a moment where you can talk to the employer and say, okay, what can you do to make sure that doesn't happen again? And in the majority of cases, that's exactly what happens. Now, there are some where an inspection is necessary, and OSHA does those.
I guess I ran out of time, but thanks much.
Thank you, Mr. Grossman. The chair now calls on the distinguished gentlewoman from North Carolina and my co-chair of the HBCU caucus, Ms. Adams, for 5 minutes.
Thank you, Chairman Byrne and Ranking Member Takano, for convening this hearing. And thank you to all the witnesses for your testimony. I want to particularly recognize Mr. Hill for coming all the way from my hometown of Greensboro, North Carolina. Professor Michaels, your testimony noted that 8 million public employees in this country remain without the guarantee of a safe workplace, despite the fact that many do work every day that's dangerous or more dangerous than work done by private sector employees who receive OSHA protection. Who are these 8 million workers, and in what states do they work, and what should Congress do about it?
This is of great concern and should be to all of us. The OSHA law is written that federal OSHA has no jurisdiction over state, county, and municipal employees. If a state decides to have their own OSHA plan, as 21 states have, as North Carolina has, as South Carolina has, those state plans will cover those state workers. But in states where there's federal OSHA, the state has an option to have their own plan. So New York, New Jersey, Connecticut, Maine, Illinois are states that have done that. But in so many other states, in Georgia, for example, state workers, in Alabama, for example, state workers have no coverage. And when a worker is killed in a sewage treatment plant or as a part of a road crew and they work for the state or a county, there's no OSHA investigation. There is no follow-up. They have no rights to a safe workplace.
Okay, thanks very much. It's my understanding that North Carolina remains one of 3 states that provide workplace safety statistics about only the cases that they investigate. This method potentially leaves out dozens of incidents of unsafe workplace practices. So what can Congress do on the federal level to ensure state workplace safety statistics are as comprehensive as possible?
You know, I don't know the specifics that you're referring to, but one of the general, the OSHA law says that states can have their own plans, but they have to be at least as effective as OSHA. And one of the areas that OSHA has been, has really not done the job it should do, and I blame myself as much as anyone, is to go into the states which have state plans and make sure they're doing everything at least as effectively. They don't have to do it the same as OSHA. And some states, California, for example, has some standards that OSHA has not been able to implement. They have a workplace violence standard, for example, which is very important to protect healthcare workers. So states can go beyond OSHA, but they can't be behind federal OSHA. And I would hope this would be an example where OSHA should step in.
And Mr. Hill, you have experience working within the construct of North Carolina State OSHA plan. Could you mention some ways that the Greensboro Builders Association has collaborated constructively with the State Department of Labor in this regard?
Yes, thank you, Representative Adams. We have a unique relationship with our Department of Labor in Raleigh. Unique in that if I have a question, I can call somebody, I get somebody to answer the phone, and I can get an answer to what I need. So our relationship with the Department of Labor has been very good in the last few years, and they actually are partnered with us. A lot of our events, they're actually present. We do a lot of stand-downs across the state where they come in and actually train the workers on a specific site. We gather them all together, put them in a tent, and we have training with them. So our relationship with our Department of Labor in North Carolina is a true partnership with them in our state.
Thank you very much, and give my regards to the Greensboro Builders Association.
Thank you.
Appreciate that. Mr. Chairman, I yield back.
Thank you, Ms. Adams. The chair now recognizes the gentleman from Georgia, Mr. Ferguson, for 5 minutes.
Thank you, Mr. Chairman, and thank you all for being here today. I want to spend a little bit of time focusing on the small business aspect of this. Mr. Gertzenberger, and I hope I said that right, listening to you answer questions from my colleague on the other side of the aisle, it reminded me a little bit of what life was like in my dental practice. We want to be in compliance. Okay, we want to be helpful. The challenge is that small business owners don't have the back office compliance capacity that you need to read through the reams. I mean, it's just daunting. I went to school to be a dentist, and at the same time, I've got to now be an HR director. We've got to be an OSHA compliance expert. So I just want to make the statement that I understand exactly where you're coming from, and my question I want to go to Mr. Hobbes on this is to say, you know, other than working with the Small Business Administration and rulemaking, can you do a little bit deeper dive into how we can partner with OSHA to make sure that we're in compliance, to make sure that we're taking care of our employees, but not living under the fear of if we don't do one particular thing right, there's a $10,000 fine waiting on the back end for us. That's it's this prescriptive nature of regulation that is it really is so hard for small businesses. We don't want to be out of compliance, and we think that we are. But when we're having to deal, in my case, with bloodborne pathogens, we think we're doing everything right, but we would welcome someone to come in and say, hey, here's a better way of doing it, instead of, oh my goodness, you did not document the third item in the 5th paragraph in the 6th book, and here's a $10,000 fine. Same thing with MSDS sheets. Talk a little bit about what more can be done to partner with the small business community.
Thank you, Congressman. I've been focusing on, and I believe wholly in, compliance assistance. This goes back to a fundamental problem, I'd suggest, with the agency, not with any particular administration, but with the agency generally, because it views itself only, or has traditionally viewed itself only, as an enforcer rather than as a partner. Now, there's some breaches in that dam, I realize, but fundamentally, I have compliance officers recently who are relatively insecure coming into workplaces, flashing their badges and threatening warrants immediately out of the chute without any resistance by the employer in the first instance. Even police officers and police departments set up community centers, and they give baseball cards to kids, and they go door to door, and they kiss the babies. They want to be partners with the communities in which they live. And OSHA's never really gotten that, in my view. And I know Dr. Michaels is chafing at the bit to comment. I don't believe the agency...
Dr. Michaels is not recognized, so please carry on.
I appreciate that, Congressman. Compliance assistance and assistance generally, being a resource, being viewed as a partner rather than as an adversary, is critical. It's critical to the success of safety and health in the workplace. With all due respect to Dr. Michaels, when he took the helm of OSHA many years ago now, one of his first comments was, there's a new sheriff in town. well, then you'll wonder why employers are not too fond of partnering with the agency or believing that the agency is going to be a partner. I mean, a lot of it has to do with image, but a lot of it has to do with acting on what ought to be the image of the agency being an assister and not just an enforcer.
May I respond to that? That was a mistake.
No.
But I never said there would be a new sheriff in town.
Dr. Michaels,
Yeah.
I'm going to reclaim my time right here.
That's fine.
Because I think Mr. Hobbes brings up a very valid point here, and that is that whether it's perception or reality, many of us in the small business community truly fear an interaction with OSHA. Okay, it is probably second only to an interaction with the IRS, and that may be slightly behind a plaintiff's attorney coming in, okay? But there ain't a whole lot of daylight between those three entities, if you know what I mean. So I think the organization has got a lot of work to do in really reaching out and being involved and working with these voluntary compliance programs, because I will tell you, despite your remarks and your assertion earlier that most of the interactions are, hey, let's find out what happened and let's see how we can help. We find a very different environment. And with that, Mr. Chairman, I yield back. Thank you.
Thank you, Mr. Ferguson. The chair now recognizes the distinguished gentleman from California, Mr. Desaulniers, for 5 minutes.
Thank you to the distinguished member from Alabama for recognizing me. And Mr. Michaels, I'm going to give you a brief opportunity to explain the new sheriff in town, which may not be the right terminology given what's going on. Can I just start with some of my time before you take it? I want to make these comments in the context of 40 years ago when I started my small business career as a registered Republican in San Francisco, California. I was admonished by a man I worked for that it's your responsibility as a small business person to find out what your responsibility is under the law. And I agree with my colleagues that there needs to be a partnership. Mr. Hobbes, I think you put it well. The goal here is to eliminate and prevent unnecessary workforce injuries. That's what we all want. That's what I wanted as an employer. So I will give you an opportunity to both express and correct the record about the sheriff comment, Dr. Michaels, but I want to talk about prevention and then disincentives. So in the far end of prevention, on the criminal prosecution, recently when the new secretary came here, I told him a story about two refinery incidents when I was in local government in my jurisdiction where people were killed. One of them happened when there were over 300 citations from Cal OSHA at this refinery, and they choose to appeal all of them. During those appeals, there was a loss of life and a massive explosion that caused not just that loss of life, but the cost of fuel and gasoline on the West Coast to go up because that refinery was shut down. Almost a year later, we had 4 more people killed in a very similar incident at the same refinery. The extensive review that we went through from that resulted in the 2 largest fines in the history of the state of California, but it didn't change the culture in my view. Fortunately, we were able to put new regulations in, shut them down for almost a year. So, and I admonished our district attorney at the time that he should at least file charges for misdemeanor charge against the CEO of a Fortune 100 company. So this prevention and holding responsible for bad behavior is really what I think we should all be talking about, and the appropriate role of the federal government and the states in being efficient at delivering advice and incentives to make sure that we don't have people who go out on longer-term injury. So my question, 2 questions to you are prevention and consequences at the far end. And then lastly, you're allowed 5 seconds to explain the new sheriff in town.
Thanks. No, prevention is key. And what I saw very clearly as head of OSHA is employers are different. And some respond to the carrot, some respond to the stick, some need a very big stick, and some need no stick at all. And OSHA has to have all those tools. But to say to do one and not the other doesn't work. And so that's why you have to do it. Now, one of the reasons you hear that, like, the state of North Carolina was very consultative, but OSHA is not, is because it's structured that federal OSHA supports every single one of those state offices that does that consultation for small businesses. But it's not called OSHA, but OSHA pays 90%, it's a 90-10 match. And the way that works is small businesses sometimes, I'm sorry, Mr. Ferguson has left, but don't want to see the OSHA inspector in there, so OSHA pays the state to do that work. That's what we do for small businesses. And everybody says, where's OSHA? But that's where OSHA is, and the fact that that's not understood is unfortunate. But that's the prevention, and it's done for small businesses. We don't think the large businesses need to have OSHA tell them what to do. It's their responsibility to figure it out. But for small businesses, like some of the tree care companies, we want that. I'm grateful for Mr. Gertzenberger for talking about the Harwood grants. Very important. OSHA does lots of this outreach. Now, just for the record, Hilda Solis made the new sheriff comment long before I got to OSHA, and I've never made that comment.
Well, she was from California, so that's what we do, you know. So on holding people accountable, so to the question of Mr. Hobbes, I think there's a commonality here. When you talked about targeting people who are repeat offenders, when we redid our workers' compensation system in California when I was still there, it was targeted both at the higher risks, but also the people who continually worked these kind of environments. We had a bakery in Los Angeles that had lots of exposure by the LA Times, but they continued to have loss of limbs. So this holding the individual responsible, I think, is really important. Could you, Mr. Hobbes, talk about going after the really bad actors, which I think we would all agree to do, and how you truly disincentivize personal responsibility or poor personal responsibility at the top of companies?
Thanks, Congressman. Yes, none of us here is going to defend the bad actor. The problem is that we can't design a system presuming that all are bad actors.
Agreed.
And acting that way. There needs to be, as I said earlier, smart enforcement, smart regulation that targets. And I believe the various OSHAs of the past, including Dr. Michaels' OSHA, have in good faith tried to use the limited resources they have to target as best they can the bad actors. There has to be disincentive for bad acting. The problem is that the disincentive needs to be targeted at the bad actors and not at everybody.
Thank you, Mr. Chairman.
Thank you, Mr. Desaulniers. And that is the end of the committee's questions. I'd like to again thank our witnesses for taking the time to testify before our subcommittee today. Mr. Takano, do you have any closing remarks?
I do, Mr. Chairman. Shall I proceed?
Yes.
Great. Well, I want to thank you again, Mr. Chairman, for holding today's hearing. What we heard today only reinforces my support for the critical work that the Occupational Safety and Health Administration performs daily to protect workers from illness and injury at work. Occupational illness is now the 9th leading cause of death in our country, claiming the lives of 95,000 working people every year. Another 5,190 people were killed last year from traumatic injuries. Preventable injuries at work have claimed the lives of people like Ralph Avery Zorns, who was killed when he was thrown from a scissor lift that was struck by an overhead crane at a warehouse in Georgia. Or Jason Weston of Nebraska, who was strangled by the safety harness that was meant to protect him, but his employer did not follow proper lockout tag procedures. Or Douglas Tout from Ohio, who suffered fatal injuries from falling from a roof after his employer failed to provide fall protection. Or Neil Carey, who fell from an unprotected area onto the warehouse floor. Or Dirk Remington, who was killed when a 360-foot radio broadcast tower buckled and collapsed on him because of a failure to follow basic safety procedures. I want to thank the family members of these workers, Leslie Crawford, Allison Weston, Tina Tout, Jean Carey, Dale Remington, who shared their stories of losing their loved ones, even though they could not be here today in person. I want to thank the United Support Memorial for Workplace Fatalities, who helped bring their stories to Congress. Mr. Chairman, these are examples of preventable workplace fatalities that happen when safety training is not provided and when there is an inadequate deterrent for employers who willfully or repeatedly endanger their workforce. This is what happens when there are inadequate safety standards and when there is inadequate funding for OSHA to inspect workplaces more than once every 159 years. The Trump administration's proposal to cut OSHA's funding by $3.1 million for the upcoming year and plans to eliminate the Susan Harwood training grant programs are troubling, especially when it should be obvious to everyone that OSHA needs more funding to carry out its basic function. Decisions to roll back something as basic as requiring employers to maintain accurate injury records, or to nullify procedures to ensure the government does not spend taxpayer funds on contractors who willfully and repeatedly violate worker safety standards sends a signal to workers, and that signal is you are on your own, your government is not here to help you. Every worker deserves to come home safely to their families at the end of the day. Let's work together here in Congress to achieve that goal. Mr. Chairman, I ask unanimous consent to insert the following items to the record. The testimony of the family members of the 5 workers I mentioned who were killed in preventable workplace accidents, and a March 2018 article in the American Journal of Public Health by Professor Adam Finkel entitled, "A Healthy Public Cannot Abide Unhealthy and Unsafe Workplaces," which documented the harms being imposed by the Trump administration's rollback of worker protections.
That objection so ordered.
Thank you, Mr. Chairman. I yield back.
Thank you, Mr. Takano. Gentlemen, thank you for your superb testimony. I thought that was really good. Good, thorough discussion, and we appreciate all the different experiences you bring here and your different viewpoints about things. Mr. Hill, I think you said it very well. We are all responsible for worker safety. Everybody is. Every time I go on a work site, I see that printed. I hear everybody, not just the safety personnel, but the supervisor, everybody saying that. But I think that includes our subcommittee and the full committee. We all have a responsibility. And certainly, OSHA has a responsibility. If we were just going to rely on the fact that you're liable, then we don't need OSHA. We wouldn't have created it in 1970. We had workers' compensation statutes back then, and they were deemed to be insufficient. So OSHA does have a responsibility here, along with employers, along with those of us that serve in Congress. And it is extremely difficult in certain circumstances for smaller businesses to comply with lengthy, detailed OSHA regulations, standards, et cetera. I've read a great many of them. Mr. Hobbes, like you, I went to law school. I was a labor employment attorney. You think that somebody like me could read those things pretty quickly and understand them? No, sir.
No, sir.
It took me a long time sometimes, and my clients would have to spend a fair amount of money trying to get me to understand it. What about them? Small business. I mean, they can't figure it out on their own. Mr. Hill's got that big, thick book over there. Can you imagine somebody on a construction site running around with that big, thick book saying, wait, let's stop, let's pull out the book, and let's see if we can all agree upon what it says? No, we've got to do better than that. We do need to have assistance from OSHA to help arborists comply, to help home builders comply, to help manufacturers comply, et cetera, help people in the dentistry business comply. It's hard to comply, but if we all have that responsibility, we all take it seriously, we can get there. I was disturbed when I looked at the expenditures by OSHA prior to last year and how much money they'd taken out of the assistance program, how many personnel were they were down in that program, and shoved it over to enforcement. I think that was an imbalance. I think that was a big mistake because we lost the opportunity to prevent injuries before they occur. It's terrible to sit there, as I have and Mr. Hobbes has, Dr. Michaels, you probably have, and show up right after somebody's died in the workplace. It's just terrible we failed somehow. We want to stop that from happening in the first place. And that means you have the appropriate standards and regulations in place, but you've got to help everybody. The employers, the people that work for the employers, and the employees on the front line. Everybody's got to understand what those standards are and what are the best practices we can follow to make sure nobody gets hurt, much less killed. It seems to me OSHA's lost its way over the last several years. We went off the, Dr. Michaels mentions the Volks rule. There was a federal court that said that OSHA couldn't promulgate that regulation. OSHA did it anyway. Had nothing to do with safety. So I was proud to be the sponsor for that bill, which passed both houses, signed by the president, simply to bring OSHA within the confines of the law. If OSHA would stick within the confines of the law and do its job and work with the employer sector to do that, we can keep fatalities and serious injuries from happening. Your testimony has been extremely valuable to this committee. We thank you for your time. There being no further businesses, the subcommittee stands adjourned.